Well, you all know I'm Erin O'Connell. I'm at the Second Judicial District Court, and I am the chair of the Access to Justice Commission, and I think I was recently appointed chair of this commission. And we are thrilled today to have Lucy Ricca with us, and I'll just give you a little bit of her background, and Lucy, feel free to flesh this out more. But Lucy is the Director of Policy and Programs at the Center on the Legal Profession at Stanford Law School. She lectured at Stanford while serving as the Executive Director of the Deborah L. Rhodes Center on the Legal Profession from 2013 to 2018. She's a national expert in efforts to reform regulation of the legal profession and a member of the task force that developed and implemented the Regulatory Reform Project in Utah, and has worked as a special project advisor on other regulatory reform projects. As I mentioned at the outset, she's a Dartmouth College grad, a UVA College of Law grad, practiced white-collar criminal defense, clerked for a U.S. District Court in Virginia, and apparently she was tired of the East Coast and decided to fly over to the West Coast and is now stationed at Stanford, as I just stated a moment ago. Lucy, we're thrilled to have you here today and look forward to hearing from you. So please, let me turn it over to you.
Thank you so much. And it's such an honor to be presenting to such an illustrious group. I'm really thrilled, and I'm excited to see what direction you all take. And the cool thing right now, I think, is, when I started doing this with Utah, very little had been done at the time. Washington had had their sort of experiment with triple LTs, but that was really it. And now there's just a lot of movement in this area across a lot of different options. And I'm going to talk a little bit about that today. So I think the timing for you all is really exciting because there's a variety of ways to kind of start thinking differently about how to regulate legal services. And I think the urgency is more acute even than it was when I started with the Utah project in 2018 because of the acceleration of generative artificial intelligence and the way that we know people are going to be using technology for just, basic legal information and even legal advice. And so I think we as a profession haven't necessarily grappled with this. And I think it's something that we have a responsibility to do to make sure that consumers are helped and not hurt by these products. And so I think it's just a very exciting time for you all to be embarking on this work. So I have a little deck. So maybe let me see if I can figure out how to show it to you all. Here we go. Okay, can you see that?
Yes, it's in your present, it's not in presentation view, but now it is.
Okay, great. I can't see you all anymore. So if someone, let's see, maybe if I toggle back over here again, but then I can't advance it.
I can track the chat and questions, Lucy.
Okay, cool. Great. So I'm just going to run through this pretty quickly, and some of it will be review for you all. And then, I'll spend a little more time on, I'm happy to answer questions. In the area I know the most is Utah, obviously, but I have made it my business to track a lot of this work. So anyway, I'll just run through this and then we can do questions and answers. And please yell at me to stop if you have questions along the way. So obviously this access to justice crisis is not news to anyone on this particular meeting, but my mentor and former boss, Deborah Rohde, who wrote about these issues from the time she was in law school and really wrote specifically about the regulation of the legal profession. This is one of her most famous quotes, that it is a shameful irony that the nation with the highest concentration of lawyers fails so miserably to make their services available to those who need them the most. She wrote a version of that sentence for 40 years, and very little changed over the course of that time. And we know that many lawyers are doing their best to help those who need it the most, but it's just has not been enough, and that crisis has only accelerated and expanded. So as many of you are probably aware, the National Center for State Courts landscape report from 2015 found that in approximately 3/4 of civil cases in state court, at least one party is self-represented, and that's millions of people, because we know that the state court dockets are the vast majority of cases in this country. In certain areas, obviously that's much higher. This is new data specific to New York, but it likely holds across most jurisdictions, that in eviction, tenants facing eviction, and parents in child support cases, the numbers are much, much higher. And we know that this also applies in federal court, that the majority of appeals in federal court are pursued by unrepresented individuals. So those numbers, I think, articulate the visible pro se crisis, what we see in terms of people showing up without lawyers at court. But we know that there's a much bigger crisis underneath that's pretty invisible to even those of us that are very active in this space, right? These are lumpers, people who take no action even when they have a legal problem. And a lot of Rebecca Sandifer's work has, the genius of her work is illuminating and making visible this issue, but still we have not done much to address it. And this, has ramifications. Just 28% of low-income Americans think that the civil justice treats them fairly. So as you all are quite aware, there are a lot of causes to this issue, but the unauthorized practice of law definition has real implications in terms of how people are able to engage with the legal system and in terms of the ability of providers to help them. So it's defined differently in every state, as you know, and it's defined pretty broadly in most states. And it applies to work that is obviously within court context, but also much, much more broadly outside of that, the application of legal principles and judgment to the circumstances or objectives of another person or entity. So, that in a really strict definition of that, if I were to park in front of a hydrant and ask someone whether they thought I was going to get a ticket and they told me they thought I would, potentially they could be doing committing the unauthorized practice of law. And in many states, including my state, that's a crime. And so really significant, broad, expansive definition, and pretty significant consequences. So these rules, and specifically the unauthorized practice of law rule, and as I'll talk a little bit more about when we discuss the entity regulation piece, intertwined with Rule 5.4, which governs the financing of legal services, they force litigants through two doors: either lawyers who cost a lot of money or kind of go it alone, and they make middle door generally illegal. Not in every case. I think we all know that, in many circumstances in federal administrative and state administrative proceedings, you can use non-lawyers for help. But generally, the rules make it very difficult for this to happen. So as I said, there are a lot of causes to the justice crisis, and there are many solutions, all of which I tend to be very much a yes and person on this, many of which would make significant impacts. And so these are some of them. But what I have focused on, and what you all are focusing on right now, is looking at the rules and the regulations that govern legal practice that limit the provision of legal services to one very expensive, very highly qualified option. And so the project that we're engaged in now is really saying, well, it doesn't really have to be that way. And if we wanted to change it up, what could we do? And how could we do it in a way that protects consumers and make sure that they're not harmed by new services coming online? So, as you all are aware, a lot of states have been engaged in this, and this map is relatively up to date, I think, although it's so fast moving in this space these days. But I made this not that long ago. So states that are kind of exploring, you all will see you're in blue there, which is interested or exploring reg reform options. And I made that category relatively broad, but this is really different map than when I started working on this with Utah in 2018. I have Washington in red and green because of the triple LT issue. They are moving forward with a sandbox, or it sounds like they're moving forward with a potential sandbox model. California, Illinois, and Florida have all sort of shut down regulatory reform efforts, and I'm spending a lot of my time thinking about how to get conversations restarted in California these days. So let's just dig really quickly into why I think this is such an exciting area right now, which is these three, I think of them as three emerging categories of regulatory reform, all of which have the same kind of goals, which is to allow more providers. The third one is more focused on access to capital. The first one is allied legal professionals, which is the licensing of, or this could also be called limited license advocates, licensing legal paraprofessionals. And in that map that I just showed you, most states that are moving forward with some version of this program, which makes sense to me. I'll talk a little bit more about it on the next slide. The second one is the authorization of community justice workers. This is a little bit different from the first bucket, and I can explain a little bit more why, but it essentially gives a UPL safe harbor to non-lawyers who are sort of certified or authorized under the oversight of direct legal services organizations or authorized community organizations. And usually those workers are limited to free provision of services. And the final one is entity regulation, which is only happening right now in Utah and Arizona in any kind of formal sense of the word. And this is where the first two are a little bit more about people providing services, and the last one includes people for sure, but the authorization hook, the regulatory hook, is an organization, is an entity. So whether that's a for-profit company or a professional services firm or a nonprofit, the entity that gets the license and the one that is responsible for complying with the regulatory requirements is the organization, not the individuals. The individuals within the organization may or may not have separate licenses, depending on the model, and I'll talk more about that. But the hook is the entity itself. And then there's just additional layers. The regulatory sandbox is a specific thing, which I'll talk more about. There's obviously, I'm sure you've heard about the First Amendment challenges to the unauthorized practice of law bans that have been brought in federal court in New York and South Carolina. Those are very, very interesting, and we are watching to see what happens there. And then alternatives to the bar exam. Recently, Oregon just moved forward with an alternative pathway to the bar exam. So just a lot happening, which is very exciting. So I wanted to dig a little bit into each one of these, but I'll go pretty quickly through the first two and spend more time on the last. Allied legal professionals or licensed legal advocates. This is a new license for legal paraprofessionals to offer legal advice and other assistance in limited areas of law and under sort of a limited scope of authorization. The model is nurse practitioners. And as I said before, this is the model, the reform model that is gaining the most traction across the country. And to me, this makes a lot of sense because it's the most like lawyers, right? It's not that different. It's just a more limited license. Often in some states, they require folks to work under the supervision of lawyers, but it's familiar to us. You're authorizing an individual person to act in a specific role. They can just be folded into the bar system and the disciplinary process. It's not very different from what we do with lawyers. It's just slightly fewer requirements and a more limited scope of authorization. My concern with this, I have two concerns. As I said, I'm a yes and person. I think all of these things should be explored and probably implemented. But my concern with this, my two concerns are, number one, what we've seen, and I think this is what happened in Washington, is a tendency, because often it's lawyers who are coming up with the requirements for licensing and for, exam and educational requirements or experiential requirements and fee requirements and whatnot. There's a tendency to overregulate. So to make the requirements not really that much less than lawyers, which really undermines the ability of this solution to be a lesser cost solution for consumers. And it also undermines like people's interest in getting into that pool. I think that's what we saw in Washington, and that's no beef with Washington because they were the very first to do this. They did a long time ago, and you know, a first mover, as I can attest to in Utah, you're trying something new, and you may not get everything right. But I think we learned from watching that, and I think what you're seeing emerge in some of the other states is an attempt to not err too much on the side of overregulation. I don't know that we've gotten it quite right anywhere yet, but anyway, the other concern that I have is on impact. You know, I think our justice crisis is so immense that I don't know how much of an impact licensed legal advocates will have, particularly if, again, with that overregulation problem. And the other issue is that, you know, and I don't think this is a problem. I actually think this is a benefit. But I think if people are expecting licensed legal advocates to serve the indigent, that's not really likely. Parentheses, New Hampshire at the bottom there. But I think this is a really great potential solution for the middle class and small businesses, which we know are a huge part of the justice gap and a very unseen part of the justice gap. But you have to be really clear going into it that, you know, this may be a solution that is more for middle class folks and for small businesses. And we may need other solutions like community justice workers and court process reform for indigent folks and low income folks. So in these programs, we're seeing a kind of a range of emerging programs. As I said, Washington was the first mover, a little bit too heavy on the overregulation side. It was sunsetted by the Supreme Court in 2020. I think it seems pretty clear, although the line from around sunset from the court and from the bar was that this was a cost. They felt like it was too expensive of a program for the results that they were seeing. It seems pretty clear that there were significant political issues at play as well. So it's unfortunate. I'm hopeful that they will revisit and reopen the program, but I haven't heard anything definitive on that yet. Arizona I think is a really interesting program. They have the most expansive model. They have authorized LPs in family law, limited civil, juvenile court, state admin law, and they are allowed to represent folks in court. And they have both an educational and an experiential track. New Hampshire is relatively new, relatively new to Arizona comparatively. And it's super interesting for a couple of reasons. Number one, it went through the legislature, not the court. And it's a statute now that then the court was directed to implement. And the first phase of it is in family and landlord tenant. And the paraprofessionals are limited to working with an attorney supervision, and they are limited to providing services to folks that are up to 300% above the federal poverty line. Right now, they're not allowed to appear in court, but in the second phase of the project, they will be allowed to appear in a limited list of courts in New Hampshire. And those are just two examples. There's lots of different Colorado, Oregon, Minnesota. And so lots of different models to look at and see what makes sense. So community justice workers, this is, again, another relatively new area that sort of began to bubble up. And this is, again, different from licensed legal advocates in that it's not a centralized top-down licensing structure for individual providers. Instead, and Alaska is the most expansive example of this, but it's essentially providing a waiver of UPL to an organization. So it's a kind of in-between entity regulation and licensed paraprofessionals. The organization gets a waiver, and it says, people working with these organizations will have a safe harbor from UPL enforcement as long as they're within the kind of supervision of these organizations. And these are trained lay community providers who can do limited legal services under the affiliation with that organization. So Alaska rolled this out with a rule change in, I think, about a year ago. And I don't know if you all have had the pleasure to meet Nicole Nelson, the former executive director of Alaska Legal Services and the new CEO of Frontline Justice, but she's a force of nature. And this program is really, really interesting. They've leveraged the community health network and the tribal health network, and have, kind of built up a legal services network alongside of that. So they already had in less than a year from getting the authorization, they'd been kind of experimenting with it in advance, but have over 300 people signed up to get trained, and they're starting with SNAP benefits. Delaware has a sort of similar program, which is allowing tenant advocates who are working under the supervision of legal aid to represent tenants in eviction. The interesting thing about this was that I think Delaware realized that landlords didn't have to have lawyers representing them in eviction proceedings. They could have sort of a agent of the company or agent of the landlord representing them. But tenants had to have a lawyer, and that didn't make a ton of sense. And so now they've developed this. It's a relatively limited program, but it does allow tenant advocates to represent tenants in eviction. And then Utah, again, this is where the sandbox is a little bit different. We have multiple projects in Utah, including a couple with I4J, which is the design lab center space affiliated with the University of Utah and the University of Arizona, training up medical debt advocates and housing stability advocates. And we have a separate program of lay DV advocates, and that's associated with the legal aid center at BYU. And so the sandbox is interesting because we've just created a space in which people can try multiple different things, and we don't have to kind of ideally, we don't have to create separate certification programs or put out separate administrative orders for each of them, because they can happen through the sandbox. And then the key with the sandbox, of course, is, as I'll talk about in a minute, is tracking the data. So entity regulation is the final piece of this. And this is the piece where 5.4 comes into play, Rule 5.4. And this is what's happening in Utah and Arizona, and what had happened in England and Wales and Australia in the earlier 2000s. And this is, as I said, the authorization and regulation of organizational providers. The first step to doing this in the States would be to regulate law firms. We don't really do that now. We regulate the lawyers in the firms, but we don't actually have any regulatory authority over the firms, usually. Not always, but usually. Some states do. But the key to this, and why entity regulation becomes important, is if you want to authorize non-lawyer financing or ownership or investment, or allow lawyers to work as employees in non-lawyer companies, providing legal services for the public, to have authority over those entities, and over those non-lawyers, and make sure that they are not interfering with the independence of legal judgment and the specific duties that lawyers have. Entity regulation becomes important, because then you say, okay, to offer legal services as an organization, you have to become licensed, and when you're licensed, here are the kind of compliance requirements that you have to fulfill. And so Arizona has one TAC, which is specifically authorizing entities with full or partial non-lawyer ownership to offer legal services, but they can only do it through lawyer employees. And that's very similar to Australia, England, and Wales. So it authorizes the entity, but the providers of legal services still remain just lawyers. So it allows for the financing. It allows lawyers to go into business with, accountant partners or business partners, but it doesn't allow for other UPL waivers within that context. In the Utah sandbox, that's the big difference, is that entities are authorized with full or partial non-lawyer ownership, but they can use technology, they can use allied legal professionals, they can use justice workers, they could use customer service representatives and or lawyers to provide limited legal services. So there's just more, and it's the entity that's on the hook, if there's a problem. The other difference with the Utah sandbox, of course, again, is the data. There's a really robust kind of back-end data component to that. So let me talk a little bit more about that. So the sandbox is kind of woven through everything that I just said, because it was intentionally created as a space that would allow a diversity of providers to provide services and be able to regulate them regardless of what the business model was or what the service model was, through this kind of collection of data. And the purpose of that was really specifically because, as lawyers particularly, but generally, we don't know what we don't know. This has been such a restricted market for so long, and we need really robust innovation and really robust investment to drive innovation, particularly technological innovation. So the sandbox was purposefully designed to have low barriers to entry, not to create kind of a centralized model of what a business or a nonprofit must look like and how they must provide services, but to allow them to determine what that is, and to say, okay, you can do this. Here are the kind of ground rules. You can't harm consumers, and here's how we're going to make sure that you don't harm consumers. You can't interfere with lawyers' independent judgment. And we're going to collect data, really detailed service level data every month from you. And we're going to look at that. and if we see problems, that's when you're going to have a problem from a regulatory perspective. We also do additional kind of more proactive regulatory activities, such as audits of higher risk entities that are using non-lawyers or technology. But within the sandbox, there's a real diversity of the types of entities that are in there and how they're providing services to consumers, but all of them have to produce the same data to us. And they all have to meet kind of that core, we would think of it as competency in the lawyer context, but core quality standard. And, the regulatory triggers for enforcement are based on evidence of consumer harm. So this is as of August 2023 for the Utah model. And I'll talk a little bit more about the political difficulties if folks want to. We've had a little bit of a lull this year. We had some staffing issues and whatnot, and there was some political pushback. But overall, it's been a pretty great success in basically the 2 years since or 2.5 years since we were up and running in 2020. We have 56 authorized entities, 49 of which are offering services, over 60,000 services provided, 24,000 consumers. This last one is really interesting to me, which is, over 10,000 as of August, services provided by non-lawyers, people, or technology. So and we produce this data every month and much more. The court gets a really, really detailed, very, very long report on each entity and what they're doing every month. And then we push out a public one that's much more high level to kind of protect business confidentiality. But it's a transparency that you don't really get with lawyer regulation. So this is just some research that my center did, and we need to update it. We have a clearinghouse that we try to keep as up to date as possible. It's been a little bit difficult because of the backlog, I think, in both Utah and Arizona on putting out the authorizations. But the entity regulation is obviously kind of the most different and the most sort of bold. That's a loaded term, but like most expansive reform and the most kind of concerning to the traditional bar. And so we wanted to understand what we were seeing, particularly because of all these concerns about outside money coming in. And also, I think there's a real suspicion that entity regulation, I don't think people, and I'm happy to talk more about this, I think people have trouble understanding how authorizing entities and allowing reform to 5.4, allowing outside investment could impact the justice gap. And so we wanted to kind of provide as much data as we could on this. So again, this is updated as of September, I think, of this year, but I would caution, please don't hold these numbers because neither Utah or Arizona are their public-facing websites are not up to date, and the records requests are moving slowly. So I'm not confident that this is precisely correct, but it's generally probably correct. And I'm hoping that I'll be able to precisely have everything update once I get some more reports back from the two states. But over 100 entities authorized across both organizations or both states. And this is a kind of structural taxonomy we created to help describe what we were seeing in terms of the entities themselves. And, most are still traditional law firms who are taking some outside investment, and that could be, you know, or allowing some non-lawyer ownership. So that could range from as simple as elevating a paralegal or a marketing person to partner, or it could be, you know, taking outside investment from venture capital, private equity. We haven't seen anybody go public yet. That has happened in the UK, but you know, it's not off the table. And you'll see in Arizona, it's a lot more of them are sort of framed as traditional law firms. And I will say in Arizona, I think a lot more of these are mass tort and personal injury firms. The second one is law company. This is a category that is basically a company that is formed that is primarily to offer legal services, or maybe only to offer legal services, but it's not a firm. And so what I would put in this category are LegalZoom and Rocket Lawyer, Elevate, some of the other ALSPs, Axiom. They're not structured like traditional firms. They look pretty different in how they deploy lawyers or other service providers, but they are still primarily about were formed to primarily provide legal services. New entrants are a little bit different, which is companies that haven't been in the legal space before and are coming into these areas of regulatory reform to build out legal verticals. This area to me is very exciting, and I do think it's one of the spaces, if we manage to get traction on this and get some more markets up and coming, that you could see more consumer-facing entities build out legal verticals and hopefully engage with more consumers, those consumers that we know are facing legal problems, but just not dealing with them because, you know, they just don't want to, and there's a lot of friction to finding legal services that are affordable. It also includes one-stop shops, which are, you know, multidisciplinary practices basically. And so there's a bunch of those in terms of a lawyer who goes into partnership with a financial services advisor, an investment advisor, an accountant, or whatnot. So that's the new entrant category. Intermediary platforms are marketplaces. And so we have a few of those. And then the nonprofits. And I will note, big difference here, the nonprofits are only in the Utah sandbox. And those are the ones that are leveraging community justice workers. You'll see the 5.4, most of the entities in both Utah and Arizona are majority non-lawyer owned. So that's pretty interesting. And then tech innovations. I'm hopeful we see these numbers move as, first of all, as the technology gets better and as money is increasingly deployed to make legal consumer-facing legal technology better in these entities. But we still have a bunch down here that are not identifying any technological innovation. Now, I will caveat on that you know, they don't have to say whether or not they're deploying a technology innovation necessarily in their applications. Most of them do if they, you know, because they think it'll help them get it authorized if they are using it, but they don't have to. So I don't know how, you know, there may be some that are actually doing stuff that haven't mentioned it, but I do think that most of the ones that are really thinking hard about how to use tech to serve consumers will have stated it in their applications. So that is the end of my presentation. I'll turn it off, but I just wanted to say to all of you, because I had the chance to talk to you, there is a really cool conference coming up at ASU run by Becky Sandifer that is really specifically focusing on the community justice worker piece of this. And it's going to be, I think, 2 days at the end of February. And I would highly recommend that if you're interested in this, it's open to the public, that you consider registering and coming, because I think it's going to be, the justice worker space is, I think, also going to start gaining a lot of traction. I think can really make an impact for low income and indigent folks and increase the impact of legal aid. And so, so I just wanted to make a plug for the conference. So I'll pause there and I'll stop sharing so I can see all of you. Let's see. Okay.
Thank you so much, Lucy. There's a lot packed in there, that's for sure. Let me turn it over to everyone here. Questions? I know. Asia.
Thank you for the presentation. It was really great. I was wondering, you had a breakdown there of how many clients you've served in Utah. Do you keep any data on a breakdown by income?
No. So we made a really explicit decision on this, and this is something, you know, that we did in the Utah context that would be a kind of design choice for anybody that moves forward on this. We made an explicit decision to not require entities to collect demographic data. And we did that because we talked with the entities, you know, before we kind of launched the project about this, and there were real concerns raised that, number one, that this would turn consumers off from wanting to engage with the services, that they would feel like it was already it's legal, they would feel like it was an invasion of privacy, and it would increase the likelihood that consumers would kind of turn away from their services. So we listened to them and we made the call not to collect demographic data. So we do not have income levels. We are hoping, we have outside researchers, including the Institute for the Advancement of the American Legal System, and the court is going to probably start sending out some surveys separately to try and understand a little bit more about that. So we may get some more insight into that. But from the regulatory perspective, we did not feel that it was necessary for our harm calculation as well.
Okay, thank you.
Other questions? Well, Lucy, what technology innovations are you seeing that are either troubling to you, or on the flip side of that are inspiring or innovative and that you'd like to see develop more? So I'm trying to understand more what the technology innovations could be or that are out there that are not being developed.
Sure. So my sense is that I think where we'll end up, at least, you know, in the near future, is, and this is sort of where I think I see things moving, and especially in those firms that are, or companies that are thinking specifically about technology, is that within one organization or entity, that you will have a variety of kind of tiers of service or choices for consumers. And so I think we know that from Becky's research and others, that the way that many consumers want to engage with legal services is, I want to do as much as I can myself. I want to get legal advice for these discrete questions that I have. And then, but, you know, other than that, I don't want to be forced into kind of full representation or that kind of thing. Now, there's some situations, of course, where we would want to force people into full representation, so what I'm seeing in terms of the tech deployment is folks trying to build out a robust tier of services where it's kind of DIY or DIY with assistance, where the software, and you see this with Rocket Lawyer and LegalZoom too, right? Like they have a software platform that folks can go on and, you know, do their will or their estate planning, or do their kind of small business incorporation. And then they can, if they can opt to talk to a lawyer. And the way that they do it outside of the regulatory sandbox or reform or ABS reform is they have a you can either do a prepaid legal service plan or you're referred out to a network of lawyers. And companies don't like that because it, again, creates this friction point and they can't control the quality as well as they would like. And, you know, they've had a lot of complaints about what happens once people get referred out. But so they have this, what we're seeing is this tier of software-based services that are sort of form completion robust, you know, more robust, supported by software. I think we'll see much better products as some of this new generative AI is deployed in that space. But where they're pushing the boundaries on what the software can do in terms of helping consumers identify their legal issues, identify their factual issues, and making sure that what they seek to get is what they want. So a couple of examples of that in Utah are LawGeeks, which is it's actually an existing legal tech company that it does sort of contract management software. And outside of the sandbox, it can sell, it's AI-based contract management software. And it targeted mainly corporate, that have in-house legal counsel, because that protects them. They're selling to another lawyer. The other lawyer ultimately is the responsible one for the product. But in the sandbox, they can sell directly to small businesses that don't have an outside lawyer. And so they have a system wherein the company can say, here are the main policy things that, from a contracts perspective, that we want to make sure our contracts sort of have in each one of them. And so they set these parameters, and then LawGeeks can kind of function as the outside contract management firm, primarily using the software. And so then, of course, if it's a little more complicated, it can be bumped up to a lawyer. Some of the other firms have tech for one tier, non-lawyer for the next tier, and then lawyer for the top tier. I think that's probably where many companies will end up being. And so you just see more diversity in service providers within one entity. Couple of other really cool examples. One is Estate Guru. They are an estate planning company, non-lawyer owned, and they partner with lawyers for the lawyers to kind of develop their own sort of bespoke package of will writing, estate planning services, but the consumers engaged first on with the technology, and then the lawyer themselves will have they'll sort of build in red flags that'll kick folks out if the software triggers it. This says, oh no, this person needs to speak to a lawyer before, this can't just be handled through the DIY. And then the other one is Rasa, which is an expungement B corporation. And Noella Sudbury is the CEO and founder. And so she has, again, a very robust tech platform that enables people to identify, and this is built with data from the Bureau of BCI in Utah and the courts. And so in the tech platform, people can identify whether they have records that might be eligible for expungement and start completing the forms. And then she's training up a whole tier of non-lawyer providers who are authorized to provide legal advice, who can help people complete that process. So the software will get them this far, and then the non-lawyer team will help complete the process. And they're able to do expungements for considerably less money than it costs to go to a lawyer. So those are just some of the examples, but I do think that the direction is never going to be, at least not soon. I don't think it will. I haven't seen anything that's pure software without any lawyer or person involvement in some way. I don't know that with GPT that won't happen, but we haven't seen it so far.
And it seems like Arizona has more an individual in other words, it's more supervisory over the individual, whereas Utah sandbox model is supervisory over or regulatory over on the entity level. And so really trying to get a feel for sort of the pros and cons to each model, right? In other words, whether it's a pure, licensure of the individual through, like the lawyer model, right? In other words, you study, you take an exam, you get a license, versus regulation of an entity. And so trying to get, what are your thoughts on these two models as we are truly at the inception of what we are contemplating here in New Mexico?
Yeah. Well, Arizona has both. So it has LPs, but it also has ABSs. And ABSs are an entity regulatory model, but they are, they do it more through sort of mechanisms that are more familiar to us as lawyers, right? So they have a code of conduct for the kind of, they call them authorized persons, the financial or managerial controlling people in the ABSs. The ABS itself has a code of conduct. They do background checks on those people and on the ABS. We now do that in Utah too, but we didn't in the beginning. But and again, the only providers of legal services in the Arizona entities are folks that are already regulated as lawyers. So I think the biggest difference, so yes, so there's two big differences. So one is that in the sandbox, well, three big differences. One is that in the sandbox, there's not this kind of centralized code of conduct or requirements of who has to be in what roles and what they're doing for entities. The second is that, again, in the sandbox, you can have non-lawyers working within these entities providing legal services. And then the third is that in the sandbox, there's the data collection piece. So I think the way that it shakes out, and I think that the challenge is we don't really know. There are benefits and drawbacks to both, but like Arizona, they kind of leaned a little bit more into a front-end rules-based system for ABSs, right? So you've got, and if you look at their code, which I've read many times, it's a code. Like there's all sorts of rules, there's definitions, it's who can be in what role, what they have to do, all these requirements. And so, but they don't collect any data on the back end. And so we don't know very much about the benefits or drawbacks of those rules and what's off the table there versus what's on the table and what impact that might have. And, but I think it's easier and more, probably cheaper to do it that way because it's more familiar to us as lawyers, right? We understand rules. It's easier to kind of set them down, and then you have the disciplinary. Arizona runs the discipline of ABSs through the bar as well. So that's how they handled it. That's also very familiar. I think there are real drawbacks to that part of it because we know there's big problems with discipline, the kind of discipline machine in most state bars. And again, I think the biggest drawback is you just don't know the impact or what is really happening. But the data side of it, which, full disclosure, my North Star is evidence-based regulation. That's where I would love us to move for everyone. But it's expensive. It is, it's not, and it's also not familiar to us as lawyers. And it requires, bringing in data analysts and building out a database and maintaining a database. I do think that the costs are a little bit more upfront and then it's less so over time. But it's unfamiliar to have this structure where there's not as many upfront rules. There's much more diversity of who's providing services. They're not conforming to a specific structure. And again, the cost of the data on the back end. So I think that's probably why we haven't seen anybody else follow Utah in the regulatory sandbox space, is this concern around the costs of it. I think now that we have the Utah model and we're actually building out a database that hopefully we could even share with others, but I think those costs are not necessarily as bad, particularly when you think about ultimately the goal of scale on the side of the entities. But it is what it is. So I hope that answered your question.
Yes. Chief Justice, you turned on your video. Did you have a question you wanted to ask?
No, I just finished eating my lunch.
So Lucy, I was going to ask something else regarding, you had said, I think something along the lines of how the emerging models of entity formation and regulation in the space impact the access to justice issue. And I'd love to hear a little bit more about that.
Yeah, so I think that's a difficult thing for a lot of folks when we talk about reforming Rule 5.4 to allow for outside investment to come into legal services, and why that would be something that's on the table as an access to justice solution. Like, why would that be a part of this at all? Fair question. I think, we have a lot of, I'm hopeful that we will begin to see some more evidence that helps us understand the connection here. But the theory, which has primarily been proffered by Professor Gillian Hadfield, and then my former mentor and some other professors, which is that what we really need in the US to begin to ameliorate this justice crisis, which again is not just a crisis of the very, very poor. It is a crisis of the middle class. It is a crisis of small businesses. It is a crisis of much kind of broader economic spectrum than what people traditionally sort of think about. So if you take that point and the immensity of the crisis, and the fact that many of the legal issues that people face every day have nothing to do with court necessarily, but are legal issues that are dealt with outside of court, in whether they're transactional issues or end of life planning stuff, but the neighborhood issues, even public benefits, that kind of thing. So like a lot of these legal issues that people face in their day to day are not court type issues, and they're issues that people don't identify as legal. So all of these hurdles require really big solutions that can reach many people. And so the way that we do that in our modern economy is through organizations, entities that can serve many millions of people. So for example, like thinking about even, banking or what have you, even hospital, healthcare systems, scale drives efficiencies. And so I think that the hope is that we can get to that entity regulation will allow legal services to deploy, legal organizations to deploy capital, technology, efficiencies of organization to serve many more people through one organization. So from the model which we all the kind of traditional model of legal services, which was distilled in the 19th and early 20th century, of one-to-one, one lawyer, one client, full representation, to one-to-many, where you have one organization that is deploying many modes of service and many service providers at different levels and serving many people. Another example is TurboTax, right? Where you can make accessing a program to help file your taxes much more available to many people. There's obvious issues with TurboTax as a company, but the model of kind of using software to reach many millions of people is the hope. Big challenge that we have, obviously, is that our legal regulatory system is state by state. So that hope for scale, I think we're only going to get there if we get more states on board with entity regulation and we're able to reduce differences among the states as much as possible. So another one of my North Stars is sort of a regional ecosystem. Right now it's Utah and Arizona, where we can get sort of a coherent regulatory system or engagement between the states that enables one entity to be authorized in multiple places, because then it can serve many people across these multiple jurisdictions. So that is the hope, that by allowing outside capital to come in, to build out tech, to allow to happen in legal, that's kind of scaling that has happened in almost every other sector, that we'll be able to make legal services just much more accessible and engaging for many millions of people. And as I said, like, there are a lot of hurdles to that, not the least of which is the jurisdictional problem. But at the same time, I think the goal is really worth pursuing or thinking very hard about.
Well, Lucy, we're out of time. I may very well contact you and visit with you more. This has been incredibly informative. And we thank you for your time. You're obviously really on the forefront of all of these issues, and it's been the greatest pleasure to have you here today.
Well, thank you all so much. And as you can tell, I do really like talking about this, and I think it's so interesting. And I think we have so much opportunity here to kind of build systemic solutions that make getting legal help easier for people. And so I hope that I hope this has been helpful, and I would be happy to come back or chat with any of you individually, or whatever is helpful.
We will take you up on that offer. I promise you. There's much more to discuss. But for now, Lucy, thank you so much. If everyone else wants to hang for just a minute, we'll just talk about going forward. But Lucy, thank you so much.
Yeah, Lucy, Erin, really quick. Lucy, I really appreciate it. I work with folks in your Supreme Court all of the time, and I was really delighted to get to hear a much deeper dive on what you all have accomplished in Utah. So I'll make sure the Chief Justice knows what a great job you did.
Thank you, Chief. Well, I love the Utah court. They really have been a profile in courage on all this. You know, it has not been easy, but I think they've done a really good job, and they've really taken seriously their commitment to the public interest, and they're wonderful people.